Good day, Crime Talk aficionados. It's Saturday. What does that mean? That's right, the weekly recap of all of the top stories throughout the week, all in one convenient location. Thanks for watching. Don't forget to subscribe, hit that little bell, and we'll see you next time on Crime Talk. Okay, let's get to the docket right off the new year. Several weeks ago, in the Barry Morphew case, in regards to the death of Suzanne Morphew, the attorneys for Barry Morphew filed a motion to recuse the judge. And let's kind of go over this, okay? So the judge that's been overseeing the case against Barry Morphew, who's charged with murder and the disappearance of his wife, Suzanne, has recused himself from the case. The move followed a request by the defense to have Judge Patrick Murphy barred from any further participation in the case after a conversation between Morphew's defense attorneys and Martin Stewart, the defense attorney for a woman mentioned in Morphew's arrest affidavit. So first, how did all this begin? So back on October 13th of 2021, the court disqualified itself from hearing the case of People v. Shoshone Darke, D-A-R-K-E. I've heard it pronounced two different ways, Dark or Darky. You pronounce it whichever way you prefer. Now, this is a case in Chaffee County, and it was a misdemeanor case. And the reason the court disqualified on that case was that the firm that Martin Stewart works for, which is called McDermott, Stewart, and Ward, had entered their appearance on behalf of Shoshone Darke. Now, as the court stated on the record on October 13th, 2021, the court has a long-standing personal relationship with Sean McDermott, who is a partner in the firm of McDermott, Stewart, and Ward. Therefore, the court had to disqualify from the case. A hearing in that case was held on December 14th, 2021, and at that hearing, the court made a record regarding the court's relationship with Mr. McDermott. And for the sake of clarity, I will state exactly what the court stated in its order. And the court stated, the court has known Mr. McDermott for at least 40 years. The court attended the same schools as Mr. McDermott, including high school. Mr. McDermott is a close friend with the court's sister and brother-in-law, and they socialize regularly. Mr. McDermott is the godfather of the court's niece. Mr. McDermott and the court were both deputy state public defenders in the late 90s and early 2000s and talked often about their jobs. Mr. McDermott and the court have spent time together during fishing trips, and they socialize when they are both in Denver. The last time the court saw Mr. McDermott was at a graduation ceremony in May of 2021. Also discussed at the hearing was the fact that both the prosecution and the defense may call Shoshone Darke as a witness in the case as it relates to Mr. Barry Morphew. Now, as described in the motion and the accompanying affidavit by Ms. Itan, Shoshone Darke was also the subject of at least 2 search warrants, and her alleged relationship with Mr. Morphew was featured in the arrest warrant affidavit. That alleged relationship may be used by the prosecution in the case's presentation at trial. And if Shoshone Darke is called as a witness in this case, her attorney will be present and will be advising her regarding her Fifth Amendment privileges. It is also possible that other legal issues, such as the scope of the immunity, if given, and the scope of testimony, will also have to be decided by the court after advice and input from Mr. Darke's attorney. Although less likely from a legal perspective, it is also possible that Mrs. Darke and her attorney may try to challenge the search warrant issued by the court that involve her or her property. Now, Ms. Itan in her motion stated that the motion was filed on December 13th, 2021 because she only learned about the court's disqualification on the Darke case on December 9th of 2021. So the Colorado judicial canons also require a judge to disqualify if the judge's impartiality might reasonably be questioned, including situations where the judge has a personal bias concerning a party or a party's attorney. That's specifically Judicial Canon 2.11, paragraph A. Now, in deciding whether to disqualify, the court must consider both the actuality of the conflict as well as the appearance of fairness. Either actual prejudice on the part of the trial judge or its mere appearance can require the disqualification of the judge, even if the judge is entirely convinced of his own impartiality, he must take care not to allow the justice system to be impugned by the appearance of partiality. This concern must be given the highest consideration in ruling on a motion for disqualification to secure the confidence of the litigants as well as the reality of maintaining public respect for the courts. Now, the court in its analysis says there's two questions that the court must answer. First, does the court's relationship with Mr. McDermott rise to the level requiring disqualification? And second, does Mr. McDermott's involvement in the case require the courts to disqualify? The answer to the first question is fairly obvious. As recited by the court has a long-standing personal relationship with Mr. McDermott, and because Mr. McDermott's firm represents Mrs. Dark, and because conflicts with one attorney are imputed to a firm, the court disqualifies itself from Miss Darkey's case. Then, if Mr. McDermott or his firm represented Mr. Morphew, the court would clearly have to disqualify from Mr. Morphew's case and would have done so without a motion being filed. Now, it is the second question that is more difficult to answer. The role of Mr. McDermott and his firm is somewhat attenuated in relation to Mr. Morphew's case. The McDermott firm does not represent Mr. Morphew. Instead, they represent a person who may testify at Mr. Morphew's trial and who will likely be part of the prosecution's theory of the case. As stated in the prosecution's original response, disqualification under this circumstance presents a novel legal question in Colorado, and the case law cited by both sides focuses on the first question: does the relationship rise to the level of disqualification, rather than the second question: is the attorney with whom the judge has a relationship involved enough in this matter at issue to require disqualification? Now, apparently, this issue remains a novel legal question in Colorado, and therefore the court must do its own analysis, as the court explains. The court focuses on the wording of the rule and statute in the judicial canon. The statute states that a judge must disqualify if he is in any way interested or prejudiced with respect to the case, the parties, or counsel. The canon requires disqualification if the judge's impartiality might reasonably be questioned. Now, comments following the canon state a judge will be disqualified whenever the judge's impartiality might reasonably be questioned. Thus, the statute and the rule are very broad in terms of when a judge must disqualify, and the words in any way imply that even if the conflict is attenuated, as in this case here, the court must disqualify. Similarly, the court does not have to attach to the attorney of record on the case at issue. Instead, the conflict can attach with respect to the case. So even though Mr. McDermott's firm is not an attorney for a party to the case, they are involved with respect to the case. Finally, the canon requires the court to recuse even if the court does not believe it has a conflict if the judge's impartiality might reasonably be questioned. Here, at the very least, the court hearing this case will likely have to rule on issues surrounding Mrs. Dark's testimony. The court will have to make those rulings after hearing from Mr. Dark's counsel, and if the court rules in favor of Ms. Dark and her counsel, the argument could be made that the court was doing so because the court favors Ms. Dark and her counsel based upon the court's friendship with Mr. McDermott. Thus, even though the conflict relates to a very small portion of the case, and even though the court does not personally believe the relationship with Mr. McDermott would affect the court finds that it has no choice but to disqualify. Now, the court explored the possibility of disqualifying for only that portion of the case involving Ms. Dark, but declines to do so as the case law does not support such an approach. The court states that once a disqualification occurs, the rule requires the disqualifying judge to notify the chief judge of the district of the disqualification, and then the chief judge's responsibility to appoint a replacement judge if from within the district, or to notify the chief justice if a replacement judge cannot be appointed from within the district. This court, he states, serves as the chief judge of the 11th Judicial District. In order to avoid an extension of the conflict and replacement decision, the court as chief judge entered a chief judge directive in 2017 that transferred the replacement role to the district administrator in the event that the chief judge disqualified himself from a case. Therefore, the court grants the defense motion to disqualify Judge Murphy, and the court will have no further role in the determination of the replacement judge, and the district administrator will contact the chief justice in order to determine who is going to be the replacement judge. All right, so let's talk about what this really means. You would think, all right, we have Iris Eitan and we have Drew Nielsen, who represent Barry Morphew. Barry Morphew's girlfriend is represented by the firm of McDermott, Short, and Ward. Sean McDermott knows the judge. They're family friends. They socialize with one another, but Mr. McDermott is not directly involved in the case and therefore disqualified. You would actually think that it would have been the prosecution moving to recuse the judge in this particular case, but it was the defense. Now, the scary thing is when you recuse a judge, you're not exactly sure who you're going to get, okay? Sometimes the devil that you know is better than the devil that you don't know. Now, everything about this case thus far, I think the judge has ruled correctly on thus far to date. Frankly, I'm not exactly sure why there was an issue. I don't think it rose to the level. I can tell you, I've had cases in front of a judge, one that I had baseball tickets with in a baseball group. He was very nice, professional. When we went to the baseball, he treated my son to anything he wanted when he was very small. Frankly, when I went in front of him in court, I always felt like he gave me a harder time because he was overcompensating, but he never thought that our brief interactions resulted in a conflict. I've done cases in front of a judge who I represented his son on. And if we did a trial in front of that judge, he would tell the parties, hey, just want to let you know, Scott has represented a family member in a particular matter. I raise that up. If anybody has any objections, now would be the time to do it. No one ever raised an eyebrow. And once again, I never got any favoritism. In fact, it always seemed like he was ruling against me. So it is what it is. So let's talk about this. I think this is a case where maybe the defense may have overplayed their hand. Now, the judge in this case, Judge Murphy, he hasn't done anything wrong in this particular case. And sometimes the devil you know is better than the devil you don't know. The chief judge, when they decide to appoint a new judge to oversee this case, they will literally, put all the names in a hat, pull one out. You don't know who you're going to get. Frankly, if I was going to be in a situation and I knew the judge and I knew how he operated, that is better. And frankly, even if there was some sort of relationship, but the judge disclosed it and the prosecution doesn't object, I figure that can't hurt in one way or the other. I'm not exactly sure why the defense did it. We've mentioned this before, and I don't think anyone else has mentioned it, but the firm, McDermott, Stewart, and Ward. I know all of those attorneys. Sean McDermott, we've done cases together. Martin Stewart, we've done cases together. Tom Ward, we've done cases together. Years and years ago, Drew Nielsen, she was a public defender in a courtroom that I did a lot of court-appointed work early on in my days. So we were in the same courtroom. We talked a lot. We had companion cases together. She is a great, great attorney. I know of Iris Eitan, but I don't think I've had any cases directly with her. But the thing that I think is interesting and nobody else seems to mention is that Drew Nielsen is married to Tom Ward and McDermott, Stewart, and Ward. So you would think that maybe if there's something there, maybe the prosecution's going to file and say there's a conflict that may carry over. Now, I don't think there would be. I'd have to go back and take another look at it, but they would probably get some sort of waiver. But, pillow talk at night, you never know. If things go sour for the relationship between Miss Dark and Mr. Morphew, you never know what they will claim, and maybe somebody sold them out in some particular way. I think I would have held my cards a little closer to my vest on that particular case. And when you have a judge who, although was a criminal defense attorney in the past, doesn't necessarily mean he's going to rule in your favor. In fact, usually means he may not, but you never know when you don't know who your new judge is going to be. So be careful what you wish for. I guess time will tell whether it works out to the benefit of Mr. Morphew or maybe to his detriment. First, let's talk about Elizabeth Holmes. Now, we didn't talk about Elizabeth Holmes' case because it's frankly been going on for quite a while, and it's involving some pretty sophisticated investors who said that, well, they were defrauded out of money by Elizabeth Holmes and her company, Theranos. Well, it doesn't get the attention that, say, the middle-aged suburban housewife that goes missing and is ultimately found to be dead as a result of their spouse, because it's not as sexy as that, because, well, It's white-collar crime. Well, let's get to it. So the Theranos founder, Elizabeth Holmes, the one-time billionaire, no longer a billionaire, and the darling of Silicon Valley, who promised a revolutionary blood testing technology, was found guilty yesterday of 4 charges in her criminal fraud trial. Now, the jury of 8 men and 4 women were handed the case in mid-December after 3 months of testimony from 32 witnesses. Deliberations lasted more than 50 hours, over 7 days. In the end, the jurors convicted Holmes, who's now 37, of 1 count of conspiracy to commit wire fraud and 3 counts of wire fraud against specific investors. Well, the U.S. District Court judge handling the matter, Judge Edwin Davila, will set sentencing at a later date. Now, she faces up to 20 years on the counts, but let's talk about that. I'll go through the analysis later. Now, you have to remember, Holmes was also found not guilty of 4 charges, and the jury determined that there was no verdict on the other 3. The prosecution is now going to have to decide on those counts where a jury verdict was not reached, a hung jury, whether they're going to go forward and try those charges again. Now, the jurors told the judge earlier this week that they were deadlocked on 3 of the 11 charges. The judge later declared a mistrial on those 3 counts and scheduled a status conference for next week. Now, you have to remember, Elizabeth Holmes was once heralded as the next Steve Jobs, and she raised $945 million from some pretty high-profile investors, including the family of Betsy DeVos, Rupert Murdoch, and the Walmart founding Walton family. Now, Theranos had a peak value at one point of $9 billion, and Holmes was ultimately convicted of defrauding PFM Healthcare Masters Fund, a San Francisco-based healthcare hedge fund, out of $38 million. Lakeshore Capital Management, a fund connected to the DeVos family, for almost $100 million, and the Mosley Family Holdings, an LLC associated with former real estate attorney Daniel Mosley, for close to $6 million. Now, during arguments, the United States attorney Jeffrey Schreck told the jury that Holmes chose fraud over business failure. She chose to be dishonest with her investors and patients, and the choice was not only callous, it was criminal. Now, Schenck reminded the jury that Holmes' own employees repeatedly told her the technology simply didn't work, yet she kept raising money on false claims. Now, prosecutors also tried to convince the jury to disregard Holmes' claims that her top executive and then boyfriend, Ramesh Sunny Balwani, abused her. Now, blaming Balwani was central to Holmes' defense strategy. You do not need to decide whether that abuse happened to reach the verdict, the United States attorneys argued. This case is about false statements made to investors, false statements made to patients. In his closing argument, Kevin Downey, an attorney for Holmes, told the jury that his client acted in good faith and believed that she built a technology that could change the world. Downey said Holmes never sold a share of stock in Theranos and went down with the ship when it went down. In the first 11 weeks of the trial, the jury heard from 29 government witnesses, including former Defense Secretary James Mattis, who testified that Holmes exaggerated the capabilities of the blood testing technology, doctored reports, concealed the use of third-party devices, and faked demonstrations. Now, in a somewhat surprising move, Elizabeth Holmes took the stand to tell her side of the story. And over 7 days, Holmes testified, at times crying, testified that she truly believed in her company and often blamed her employees for what happened inside the labs. Now, Ms. Holmes told the jury that she didn't mean to deceive anyone, including the investors and patients. Now, Theranos dissolved in 2018 following civil and criminal probes. Holmes was indicted that year alongside Balwani, following a series of damning articles exposing the shortcomings and inaccuracies of the Theranos technology by the Wall Street Journal. Holmes settled an SEC case paying $500,000 in fines and agreed not to serve as an officer or director of a public company for 10 years, though she didn't admit or deny the charges in the settlement. Now, Balwani did not agree to the settlement and is fighting those charges. He's expected to go to trial later this year. So of the 11 total charges, Holmes was found guilty of 4, conspiracy to defraud investors, and 3 counts of wire fraud against individual investors, and she was found not guilty on 4 additional charges, including 1 count of conspiracy to defraud patients, 2 counts of fraud against investors, and 1 count of wire fraud stemming from ads Theranos ran in Arizona. The jury was deadlocked on 3 other counts of wire fraud and returned no verdict on those charges. Now, during the trial, Holmes' lawyers tried to portray her as a young and inexperienced entrepreneur. The attorneys argued Elizabeth Holmes worked herself to the bone for 15 years trying to make the lab testing more affordable. One of Holmes' attorneys also said in an opening statement, she failed, but failure is not a crime. Holmes testified that she hadn't intended to mislead the public or investors and had been advised to protect the company's trade secrets. She spent much of her testimony arguing about whether Theranos was responsible for this company's shortcomings. She spent most of her testimony arguing about who was responsible for the shortcomings at Theranos. The prosecution had alleged that Holmes knew about the serious flaws in the company's technology and hid the issues from investors. Former patients who had received inaccurate blood tests also testified, including an Arizona woman who received an incorrect result for an HIV test and a woman who was misdiagnosed with a miscarriage. The case of Elizabeth Holmes provides a teachable moment, not only for people who are out raising hundreds of millions of dollars for new technology, but first is 1, don't lie. Number 2, really don't lie when you're taking someone else's money and going to invest it or use it in something. If you don't use it for that, or if things turn bad and it fails, what's the first thing the person's going to do when they say that their money is gone? Well, they're going to say there was fraud. Basically, did you tell them a lie, or did you not tell them information that they should have known or a reasonable investor should have known? And if they had known that, they would not have made the investment. Always remember that. And you always have to remember when you're making investments, how much money is the other person putting in? They may be asking for money, but how much of their own money are they putting in? For example, look at Elon Musk. That guy, he bet the entire ranch with his own money, and he's made lots of people even more money, but he was willing to put his own money in for the bet. So that shows you whether somebody truly believes in it or whether they're just trying to make a quick buck. The other thing that you have to remember is that if the business venture fails, there will always be somebody complaining that you didn't do enough. So, general rule of thumb, don't take other people's money. And if you do, you better be able to provide an accurate accounting down to the penny. Everything was used for the investment and it wasn't used for your own personal use. And certainly do not lie. Bottom line. So just like the other day, this is a copy of the sentencing table from the sentencing guidelines. This is what the probation officer is going to do to prepare a pre-sentence investigation report, and they're going to submit a preliminary evaluation of the sentencing guidelines to the judge. The attorneys will each have an opportunity to make any objections. Now, this is a very general outline because there's lots of things that we will have to consider that we don't know exactly what the attorneys know that we don't know. So let's take a look at this. Under the federal sentencing guideline calculator, the base offense level for wire fraud is a level 6. As you can see, that's pretty low. But what is going to bump Miss Holmes up here is the sheer amount of the loss. And what I've done is calculate the number, which is appropriate based upon the charges where she was convicted. It looks like the total amount of the fraud where she was convicted totals $144 million. So the federal sentencing statutes will say she gets a 24 increase bump. So as you can see, she starts out at a level 6. She has no criminal history, so she'd be looking at 0 to 6 months just for your everyday routine wire fraud case. But it goes up 24 points, right? So we're at a 32, which puts her at 121 months. Offense resulted in substantial financial hardship to 3 victims. We're going to say yes on that. Give her another 2-level increase. The offense otherwise involves sophisticated means. I think one could say that lying and trying to cover it up was some sort of sophisticated means. So we included that in there. Where does that leave Miss Holmes? It leaves her at a 34. Now, she doesn't get an acceptance of responsibility because she went to trial. If she had pled guilty, she would have received a 3-level bump downward. This is known as the trial tax. If you plead guilty with the same dollar amount, you're looking at 108 months to 135 months, which is 9 years, to about 12 and a half years. Now she's up to 151 months to 188 months, okay? That's where the calculations are going to begin. Basically, 12 and a half years is where she'll probably come out. So as you can see, we plugged in here the loss of the dollar amount, $144 million. At least 3 victims. Those were the people that she was found guilty of. Was it really theft from another person? Yeah, we didn't add that because these are pretty sophisticated people. It's not like she was swindling little old ladies out of their railroad pensions to steal their money for her own gain, which, there's always a fine line in cases like this, simply because you have very sophisticated people. You had former secretaries of state on the board of Theranos. General Mattis, pretty sophisticated guy, and he apparently got duped. So that's what they all claim when they invest their money, even though they're pretty sophisticated people. Those hedge funds, you would think that they would have done their own due diligence before they invested up to $100 million. So we checked the box, but you can see all the other information that the federal sentencing guidelines takes into account, which ultimately results in a potentially much higher sentence. And ultimately what that comes down to, like I said, she doesn't get the acceptance of responsibility box checked pursuant to the federal sentencing guidelines, section 3E 1.1. She has no criminal history and she's not a career offender. So where does that put her ultimately on this chart? Level 34, 151 months to 188 months. Ultimately, she could be fined from $17,500 to $175,000. And let's not forget restitution that she'll never, ever be able to pay back again unless she becomes a billionaire one more time. But I doubt Miss Holmes will have anyone that's going to give her money ever again. So I hope that breaks that sentencing scheme down. A lot of people always say, oh, she faces up to 20 years, but what is she really going to get? Well, based upon that, you're looking about 12 and a half years. 12 and a half years for $144 million. Well, it doesn't look like she profited too much from it. It went to the company, but it was still a fraud nonetheless. Now, remember, the government will file for perhaps an upward variance, assuming they don't go forward on the other charges and saying this was so heinous, it's such a large amount of money that she should receive a higher sentence. Ultimately, the judge can sentence the maximum sentence, but the defense will file motions for downward variance and ask for a sentence lower than this, perhaps asking for a reduction several levels lower. So hopefully, for their client, she can get out as quickly as possible so that she can probably pay the lawyer's fees. And next on the docket, Ghislaine Maxwell, right? She got convicted of those 4 of the 5 counts of basically trafficking in regards to young girls. Well, guess what? I think she may get a new trial, and let me tell you why. So a juror in the trial, Ghislaine Maxwell, a guy by the name of Scotty David, he was juror number 50. And some news agencies are not reporting his name, and I'm not sure why because, well, he gave an interview with the Daily Mail shortly after jury service was done. And he told the reporters that he was sexually abused as a child and that basically he had to convince the other jurors that the victims who testified, well, that their memories weren't that bad, and that's normal because he said in his own experience he could remember some things rather vividly and that some things could not be remembered, and therefore that was just part of the trauma process as it was in his trauma process. That creates a whole lot of problems, okay? Why, you might say that? The prosecution has called for a hearing. They've also asked if the juror would like a defense attorney at his own expense. Right? Why? Well, he doesn't want a court-appointed lawyer because he has retained his own. All right? The significance is Ghislaine Maxwell is going to ask for a new trial. And you say, well, didn't all 12 jurors deliberate and find her guilty? Yes, they did. But guess what? We've talked about this before, ladies and gentlemen. Voir dire. It is one of the most important parts of a trial. It is won or lost in that process. And one of the things for there to be effective voir dire, and it means to speak the truth, to tell the truth, is that jurors have to be honest with them. Now, in this particular case, Ghislaine Maxwell, there was reportedly a very thick, I think it's up to 50 questions on a questionnaire. And I assure you, one of the questions was, have you or anyone you know been a victim of a sexual assault? Guess what? Literally an automatic qualifier. Just like if you're on a homicide case and your close family member had been a victim of a homicide, guess what? You're not going to be on that jury. Why, you might ask? Because there's a pretty reasonable belief that if people are similarly situated, that they are in fact going to become advocates and maybe try to seek justice for the people here because maybe they didn't get it in their own case. Doesn't mean they wouldn't be a good juror, but they probably shouldn't be on this jury. And that's what it appears as this juror did. He brought in his own personal life experiences and tried to use that to persuade other jurors that the experts and the testimony should not be believed. Well, guess what? That wasn't evidence that was presented at trial. If that juror wanted to present his life experiences, guess what? He should have been called as an expert. So the juror stated that he doesn't recall answering any questions about being abused in any way. My understanding is that there are now probably 2 jurors that were similarly situated. And guess what? It appears as though they were not honest on their questionnaires from the information that I have received, and they did not outline or state that they had a history of sexual abuse. Now you may say, Scott, maybe the attorneys didn't ask the right questions. It's on a questionnaire, real straightforward. And I assure you, somebody in that voir dire process would have said, if there's anything you think we need to know, now would be it. It's kind of like that case, Scott Peterson, the juror who'd been a victim of a very similar situation, didn't disclose it, writes a book about it. I think he's going to get a new trial too. You may ask yourself, well, why does this juror need an attorney? Well, guess what? The juror, when they're asked to tell the truth, they do so under oath. That's right. They do so under oath. And so in theory, one could face perjury charges. I, on the other hand, if we're the judge, based upon what we know thus far, I would issue an order to show cause why this juror should not be held in contempt, right? And if he is in fact found in contempt, I would possibly jail him, and I would also impose sanctions, which would include attorney's fees that were spent by Ghislaine Maxwell and any costs for the government as well, because if they have to redo this trial, it's all because of this juror. I would throw the book at him because we don't need jurors who are trying to get on a jury to be an advocate for one side or the other. Their job is to make a decision with neither passion nor prejudice as to the facts and the law. And guess what? It completely undermines a true, fair judicial process when somebody is on there with their own hidden agenda. Throw the book at them. All right. How about Lori Vallow? Well, she was able to listen in by phone for a hearing that took place yesterday. We brought it to you live on CrimeTalk, and you can take a look at that here if you'd like to as well. But anyway, the prosecutors, they requested this hearing to clarify a 2021 sealed court order on the release of discovery information by those with access to it. And prosecutors were specifically concerned about discovery or evidence in the case being inappropriately discussed or shared by Lori Vallow's now former attorney, Mr. Mark Means. They said that there's an ongoing concern that privileged information and documents could be disclosed to third parties and or the public. Now, the prosecutors, stated this in their motion, and they requested it at the hearing as well. As you may recall, former counsel Mark Means, without discussion with counsel Jim Archibald, filed motions publicly discussing confidential information related to Lori Vallow. So, the prosecutor in that case argued and asked that the court clarify the court order and make sure that it still applied to Mr. Means, even though he was removed from the case. If it did not, then they wanted it expanded. Now, the Judge Boyce in this particular case,
asked if they were seeking basically a gag order, and they said that they were not. Now, Mr. Archibald, Lori Vallow's attorney, objected to the motion on the grounds that Mark Means hadn't been notified of the hearing and would not be allowed to speak. He stated that it was in fact unfair to put an order on him when he's not a party to this case. Mr. Archibald also expressed concern that the order, as it stood now, may have prevented him from sharing the discovery even with his own client, Lori Vallow, because he wanted to show the grand jury transcripts to his client. The judge clarified that he could, in fact, share those with his client, but Mr. Means would be subject to the order and he cannot disclose confidential information. That goes without saying. Now, what is a protective order? Okay, a protective order is really an order by the court saying that you cannot disseminate, and it's normally grand jury information, or it's information like witnesses' names, address, phone numbers, where there's a legitimate concern as to the safety of a witness. It's not uncommon to have a protective order basically saying, hey, me as the attorney am going to assure that only my staff, my legal team working on this case, including investigators, experts, can look at this information for the presentation of a defense, but we either have to, A, not disclose it, and B, give it back at the end of the case. So it's not uncommon, and guess what? Even if you get off the case like Mr. Means did, you're still going to be subject to the protective order that you signed when you were on the case or that you were aware of on the case. So really, it's not a big deal. Do you know who's also going to have a lot of time to think about things and spend time on their education? Travis McMichael, Gregory McMichael, and William Roddy Bryan. That's right. They were all sentenced regarding their involvement in the death of Ahmaud Arbery. Now, Travis McMichael is 36, Gregory McMichael is 66, and William Roddy Bryan, he's 52. Well, they were sentenced Friday. The McMichaels were both sentenced to life in prison without the possibility of parole. Bryan will be eligible for parole, but only after he serves a mandatory minimum of 30 years. Now, given his age, let's face it, it is a life sentence. Not saying that any of these three do not deserve to spend the rest of their life in prison. Now, Judge Timothy Walmsley called the murders chilling and disturbing, and that's exactly what it was, and it was a murder. The mother of Ahmaud Arbery referred to it as a public lynching. Now, as you may recall, the prosecutors chose not to seek the death penalty, but they were all convicted at trial. Ahmaud Arbery's mother, father, and sister all gave victim impact statements, and they asked the judge to impose the maximum sentence on all three men. Now, court was required to do that, and Mr. Bryan was the only one who had the possibility of receiving some sort of parole after 30 years. And as you may recall, Mr. Arbery was 26-year-old when he was gunned down. When he was jogging on February 23rd of 2020. Now, some people say he wasn't jogging, but guess what, ladies and gentlemen? It was murder. Whether you thought he was in a house, whether he was out. And I took a lot of heat for this. I said early on, the defense that these people were going to put up, that they were somehow doing a citizen's arrest, wasn't going to fly. Thanks for watching. We'll see you next time on Crime Talk.